Welcome, everyone. My name is Adam Savitt. I'm Director of Communications at the Center for Security Policy. I'm pleased to welcome you back to our Voter Education Project series. We're holding a webinar event meant to educate the American voter on crucial national security issues every week right up to Election Day. This week, we also have an event on Wednesday, so be sure to check out the full schedule and register at securefreedom.org. Before we begin, I want to wish our Jewish viewers and supporters a good Yontif, as today is Yom Kippur, the Day of Atonement. We do regret that those of you observing cannot join us live. As with all of our programs, this will be archived on our website and our YouTube channel later today, so you can catch it before the debate tomorrow. Today's program is entitled Restoring Law and Order, Law Enforcement Options for Responding to Today's Insurrectionists, featuring our esteemed guest, Andy McCarthy, and moderated by my center colleague, Kyle Scheidler. Please note that you are in listen-only mode, but you can submit your text questions in the Q&A box on your GoToWebinar panel. I'll read those questions out loud at the end of the program. This event is being recorded, as I mentioned. It will be available on our YouTube channel and on our site, securefreedom.org. With that, I'll hand it over to our center's Director for Homeland Security and Counterterrorism, Kyle Scheidler.
Thank you, Adam. As Adam said, this is a question. We're going to be talking today about one of the probably most important issues facing America's voters as they go to the voting booths this November, and it is this question of the insurrection. Unrest continuing to spread through American cities, producing nightly images of assault and arson perpetuated by Antifa, BLM, and other hard-left revolutionary groups. We think it's especially significant to be talking about this today because of that issue. And we have with us a man that's uniquely qualified, I think, to answer some of the important questions about what the U.S. government can do and what it should do in dealing with these challenges. He's a good friend of the Center for Security Policy, Andrew McCarthy. For those of you who don't know, Andrew is the former Chief Assistant U.S. Attorney in New York, best known for leading the prosecution against the blind Sheikh Omar Abdel Rahman and 11 other jihadists for waging a terrorist war against the United States that included the 1993 World Trade Center bombing and the plot to bomb the other New York City landmarks. After 9/11, he supervised the U.S. Attorney's command post near Ground Zero and later served as an advisor for the Deputy Secretary of Defense. Andrew McCarthy is also Senior Fellow at the National Review Institute, a National Review contributing editor, and the author of a great new book, Ball of Collusion, The Plot to Rig an Election and Destroy a Presidency. Andy, thanks for coming on.
Kyle, it's a pleasure to be here. It's always a pleasure to join my friends at the Center for Security Policy, which I've not only partnered with on a number of things over the years, but have always been an admirer of the great work that you do, that Frank has always done, that Fred continues in that tradition. So it's a thrill to be here.
Thank you. So let's go ahead and jump right in with one of the reasons I most wanted to have you on to have this discussion. It was recently leaked in the mainstream media that Attorney General Barr had urged his staff to consider prosecuting those behind these riots on some pretty serious federal charges. And the one that got the most mention in the media was this charge, seditious conspiracy. Now, it's a rarely used but very serious federal charge, which allows for sentences of up to 20 years in prison. And you're sort of uniquely qualified to discuss this charge because you used it in that case against the blind sheikh. So we were hoping you could, for our audience, walk us through what is seditious conspiracy, what is required to prove it, and was Attorney General Barr right when he recommended it?
Well, Kyle, let me start with the last question because that's the easy one, and that is, yes, he was absolutely right. And the reason or the way that you explain that is by going through the questions that you've put. The unfortunate thing I've always thought, having had to research this statute and apply it in a large criminal conspiracy, is the title of the statute. The title is Seditious Conspiracy. I highlight that because the word sedition does not appear in the charging language of the statute, which, if you're talking about what people can be charged with and what crimes they've committed, it's the charging language, not the title of the statute, that makes all the difference. And I think it's probably something that wouldn't be as controversial or explosive as it was in 1993 when we invoked it, and as it's been since the leak that you mentioned of what the Attorney General had said. The reason for the controversy centers on the word sedition. So I think if the statute were called levying war against the United States or using force against the government, nobody would have heartburn about it. But the problem is twofold. Sedition is a kind of a vague term. I think the common understanding of it is action against the government. But it could also be understood as dissent against the government. It would have to be pretty vigorous dissent, I think, to fall within the common understanding of the term. But I think the sort of vagueness around it is coupled with, and this is the important point, a kind of an unsavory history that is attached to that term because of the Alien and Sedition Acts, which were enacted by one of the first Congresses in the administration of John Adams, the second president, toward the end of the 18th century, and was used to criminalize dissent against the administration. And for that reason, I believe all of the people who were either charged or convicted of seditious or sedition charges under those acts were pardoned by President Jefferson in his administration. So the term sedition has this kind of a checkered past, but it didn't stop Congress from enacting a seditious conspiracy statute during the Civil War. And the current seditious conspiracy statute is the modern, in the sense of today codified in the federal criminal code, the modern version of what Congress enacted back in, I think it was 1862, 1863. And what it does is it makes it a crime to levy war against the United States or to use force against the government. And it was, when it was enacted, it was mainly used in the free states against supporters of the Confederacy who committed acts of seditious violence in order to undermine the Union war effort. So what you hear in some of the complaints about it is that it's rarely invoked, as if the rarity means that there's something suspect about it, whereas in point of fact, the rarity is that we have the good fortune of living in a country where it's fairly unusual for large groups to conspire to levy war against the United States or to wage war against the United States or its government. But when that does happen, the statute is there and it's a perfectly good tool for it.
And you recently wrote an article about this statute as well. And one of the things you mentioned, I think it's important to highlight, was that while it does not criminalize speech, despite what its critics might say, there is an element of motivation in the statute, which is to say it becomes necessary for the prosecutor to show that it was the objective of the perpetrators to overthrow the government or to make war upon the government. And in cases where you're dealing with ideological violence, as you dealt with in 1993 with the Blind Sheikh, or as we're seeing today in Portland, where they have attempted to burn down a federal courthouse for over 100 days in a row, it's sort of not possible to talk about this issue without talking about what it is that the perpetrators are trying to accomplish. Is there anything wrong with a prosecutor doing that?
No, there's not, as long as the jury understands, and the courts are always very energetic in making sure of this in the jury's instructions. And by the way, it's black letter law that we assume that juries follow the instructions that they're given by a court. But the juries are always told that someone cannot be convicted for having unpopular views or for saying unpopular things. And actually, Kyle, if you think about how our national security laws have been enacted, especially over the last, say, quarter century or so, for example, in the Patriot Act, in some of the provisions of the Patriot Act, it explicitly gets laid out that you can't trigger this particular statute based on, say, protected First Amendment activity alone. So the line our law has always drawn is basically the use of force or incitement to criminal behavior. The First Amendment protects the freedom of speech. And the article, the, is actually important because it doesn't say you have free speech. It says that you have the freedom of speech. And that's because at the time that the Constitution was adopted, the concept of freedom of speech, as understood in British law and in colonial law, contained several well-known exceptions to free speech, such as what are known as fighting words, words that provoke, intentionally provoke attacks, incitement to violence or lawlessness, immorality type crimes like, pornography and the like, obscenity. So there were always those exceptions, and there are also obviously time, place, and manner restrictions that apply. So it's all well and good for you to have your political free speech rights. You can't scream them at my bedroom window at 3 o'clock in the morning. So we actually do have some restrictions on even where people are able to express their core First Amendment protections. So that's where the law has always been at from the beginning. Incitement to violence has always been something that could be criminalized. And the discussion about how prosecutors use the evidence of words or beliefs is a little bit radioactive in the construct or the confines of talking about sedition, because you have the whole baggage of political dissent that's involved. But if we could just put that aside for a second, it's a commonplace that prosecutors use words to prove crimes. The example I used, I think, in my in the article that you're talking about, the column I wrote a couple of weeks ago, was the mafia don who, gets asked when the fellas at a meeting in a social club, what do we do about this rival mobster? And the mafia boss says, I hate that guy, whack him. When a prosecutor uses that statement in the mafia boss's later murder trial, you're not criminalizing the statement. He's on trial for murder, but the words and what you can derive or infer about the person's intent and motive are what you get in the way of evidence out of the statement. So it's always important to distinguish what is the thing the person is being charged for from the person's speech. There's a stack of cases this high that says basically that people's speech can be used as evidence in a criminal trial, and that doesn't criminalize the speech. The only time you're in the position of talking about criminalizing speech is when my very words saying something are criminalized. And the most controversial example of that, I think, would be, for example, leaking classified information, where the very act of doing that, the words passing out of my mouth, are something that the government would say that it could criminalize. And the fact, Kyle, that there aren't that many of those cases goes to show how seriously we take all this.
I think from what you said, it raises another really important point that we're seeing right now with this issue, which is the question of organization. We saw in a recent congressional hearing with questioning of FBI Director Wray, this question of whether Antifa and some of these other insurrectionary groups are organizations. Are they organized? And this becomes a bit of a challenge. I argued before the Senate subcommittee that Antifa is organized, and they are an organization in a sense. But we see a great deal of pushback from this idea that people will sometimes joke, oh, well, who's the president of Antifa, or what is their board of directors, or where's their headquarters? And it's a joke, but they're making this argument that these are people who believe something, and there's no organization behind it. And of course, some of this gets pretty far afield from what the actual law requires. So I wanted to ask you, from your standpoint as a prosecutor, when we're talking about a criminal organization or a criminal conspiracy, what do you actually need to be able to show for legal purposes to define something as an organization?
Yeah, what you really need are people who are organized in the way of an agreement around the commission of a federal crime. If it's a federal prosecution, obviously state will work as well. I think the point that you make, Kyle, is very important because it takes me back to jihadism and a lot of the work that the center did and that I've done over the years, but particularly during the Obama years, I thought one of the big concerns that we had was the kind of minimization of the ideology of the enemy. So we were continually trying to explain that the ideology here is Sharia supremacism. And what the government was continually trying to do was call it Al-Qaeda ideology, as if you could shrink Al-Qaeda, that would make the ideology go away. So I've long been concerned that the people who run our national security policy, maybe this is in good faith, sometimes maybe not so much, but they get themselves twisted up in knots between organizations and animating ideology. And it's important to get that right, because from a national security standpoint, you don't want to believe, or you don't want to trick yourself into thinking that because you may have suppressed an organization, that you've made a threat go away. So you have to understand the difference between the animating ideology and the people who act on it. From the point of view of what an organization is, under federal law, whether you're talking about racketeering law or just ordinary criminal law, there is no requirement that a conspiracy have the rigor of the military or the regiment of the military in order to function as an organization. In fact, just to take racketeering organizations, because they're the most common place where you talk about organizations in the criminal law. The concept in RICO law is called an enterprise. And the very expansive definition under federal law of an enterprise is simply an association in fact. Now, a racketeering enterprise is essentially an association in fact that organizes itself around committing crimes and deriving the income from crimes. Some of those organizations are legitimate. You can prosecute, for example, for racketeering, a corporation or a labor union or some kind of a guild or some kind of a formal entity that's operating as an entity that violates the law and derives income from it. On the other side of the ledger, you also have, it embraces illegitimate enterprises like mafia families. Now, a mafia family or say a drug cartel may actually have something that approaches the regiment of the military in the sense that, it has ranking positions, it has a boss and an underboss and a consigliere and all that jazz. But you don't have to have that in order to have an enterprise in fact. And in point of fact, you have many, many criminal organizations that have no regiment whatsoever. And the thing that they are organized around is some purpose to violate the law. In a racketeering organization, it would be membership in some kind of a gang that exists to commit crimes and derive income. In other contexts, it would be, let's say, a narcotics conspiracy. You could have 2 people, you could have 20 people, you could have 200 people. And what they're organized around is an agreement to obtain and distribute illegal narcotics. They don't have to have ranks in an organization in order to be guilty. What you have to show is that the criminal agreement exists and there's enough evidence to tie each person to it. So I think you're quite right to say that this whole idea of approaching Antifa as if you needed to distinguish an ideology from a working organization is a fool's errand, because as a prosecutor and as somebody who's enforcing the law, what I'm interested in is, can I prove that I have a group that is agreeing to violate laws and doing things to bring that agreement about? And if I do, then I don't care about the niceties of how the crooks arrange their own activities. What I'm interested in is, here's what the law says you can't do, and here's what they're doing. And I think I would look at it like that rather than try to minimize Antifa as if it was like, just some kind of a thought process out in the ether someplace, rather than a bunch of people who are actually doing tactical things in order to violate the law, even if they're loosely organized.
I mean, would you say that just based on what you have seen so far, that there would be room for a racketeering case against some of these people behind these riots?
Yeah, well, I think that, for example, if you get people crossing state lines to commit violent crimes that are set out in the Racketeering Act, and the number of crimes that are embraced under RICO is vast. I mean, you look at the list, it takes up a page in the criminal code, all the different activities, and it's very broad. So yes, if you have a group that's interstate and they're crossing state lines in order to commit crimes, then RICO would be one thing you would certainly look at. Now, you might, this similar question came up when Rich Lowry and I were discussing this on our National Review podcast a week or two ago, when he said to me, well, what makes a prosecutor use like seditious conspiracy or RICO or something else? And it really depends, Kyle, on what you're trying to accomplish in the prosecution in terms of your target. So if I've got two guys who are trying to light a part of let's say a federal installation of some kind, of courthouse, on fire, and I really can't connect them in any serious way to any other operatives, I probably want to bring the simplest, most straightforward case I can bring. And it's important along these lines to remember that rioting is a federal crime. Using explosive devices is a federal crime. There's a lot of gun statutes that, if people, even if they have if they're licensed to carry firearms, there are a number of federal offenses that they can commit. So, there are a variety of federal crimes that are fairly straightforward. But if I want to use something like RICO, like racketeering conspiracy, or I want to use something like seditious conspiracy, I think that's very useful if you're trying to get a big organization and show how it works. So one of the reasons, for example, that we use seditious conspiracy in the Blind Shake case is because the backbone of our proof was a lot of rhetoric on the part of the defendants that they considered themselves to be at war with the United States, and they explicitly planned to attack U.S. military installations and targets that would be perceived as an attack on the country as a country. So like the World Trade Center was a big financial center. The attacks of 9/11 in this regard almost really speak for themselves. So if you want to go after a big organization under circumstances where you have to explain to the jury what they did and why they did it and how they were organized and what their motivation was, then something like a racketeering conspiracy or a seditious conspiracy can be a very valuable tool for unwinding for the jury exactly how these organizations work.
I mean, do you think, just from what you've observed over the past several years, and certainly under the Obama administration and now, 3.5 years of the Trump administration, that the Department of Justice has sort of institutionally moved away from making these sorts of cases, from even desiring to make these sorts of cases. And then, if you do think that's true, what can we do, or what should the American people do if they believe that the DOJ should be making these kinds of cases?
I think institutionally, when you talk about the Justice Department, it's not monolithic, and it shouldn't be, because the different different components have different roles, and sometimes the tension that's brought to bear in those roles is very useful, because you don't want to overestimate the strength of your case by having a bunch of people who are inclined to reinforce each other's worst instincts, and then then you have to try to prove it to a jury, and it turns out that you haven't asked the hard questions you should ask. So to be more concrete about this, when we were doing the blind shake case, let me give you an example of the kind of tension that goes on. I wanted to, because I'm the prosecutor and I have to prove the case in court, and we're looking at people, whether they are in a seditious conspiracy or not, they're certainly in a bombing conspiracy, right? So I know in the first instance, I want to bring bombing conspiracy charges. And then if I can build it into something bigger on the basis of everything we get in our investigation, that's another story. So as the prosecutor, because I need to prove the case to the jury, I would virtually like to let the case go. If you're talking about a bomb that you light with a fuse, I'd rather they let the thing go until somebody strikes a match and lights the fuse, right? On the other hand, the FBI, if the investigation gets away from us, if suddenly our informant gets cut out and these guys start to act on their own, the FBI is going to be blamed if something goes wrong, they lose control of the investigation, and a bombing actually happens and people get killed, right? So we're in a constant tug of war, but it's a good tug of war, because I'm pushing them. I'm saying, look, we don't have enough evidence yet against this guy and that guy. And the Bureau wants to take the case down yesterday because they're worried about public safety. The Justice Department, on the other hand, and now just so people understand how federal cases get investigated at the district level where the crime is taking place in the main. So you're talking about district U.S. attorneys' offices working with the FBI field office. And when the Justice Department is in its proper role, Main Justice in Washington is enforcing guidelines to make sure that the whatever the FBI is doing and the U.S. attorneys are doing is consistent with federal policy as it is controlled and derived by the Justice Department. So everybody is knocking heads occasionally because everybody's got different interests. And I think it's hard to say that the Justice Department as an institution is either for or against doing particular kinds of cases. The FBI obviously is worried, as it should be, about doing big terrorism cases, because since they're most responsible for public safety, in a perfect world, what they'd be able to do is go in and interrupt things at as early a stage as possible to make sure that people don't get hurt. And as the Justice Department prosecutor, what I would be pushing for is to let things play out longer in order to get more evidence. What the intelligence guys say is let things play out longer and then don't prosecute, because we want to get as much information as we can get. And at the same time, we don't want to take on the due process burden of telling everyone what we know. And in Main Justice, they have to basically rationalize and arbitrate all these different interests. So I certainly don't detect from the Attorney General that there's any instinct not to do these kinds of cases. And I would also point out I've had enough critical to say about the FBI, especially over the last couple of years. Let me say something good about the FBI. Notwithstanding all the political correctness that comes out of Washington, including sometimes out of FBI headquarters and Justice Department headquarters over the years, the guys who do cases on the front lines have continued to do really good, important, strong cases, whether it's in the area of terrorism or violent crime, and they do it regardless of whether the government is in control of Republicans or Democrats, which I think people ought to take some heart in.
You mentioned sort of the cases being made at the district level, and sort of also the desire to, I don't want to say charge the easiest thing to prove, but to charge at, and we're seeing that in fact, right? Like, look at Portland. We're seeing dozens of people every night charged with felony arson, which is a pretty major charge. It's a charge that can be used for building a material support for terrorism case. It's a charge that can be used for building a RICO case. But at the same time, we have this challenge with local, and these are local district attorneys in most cases, and also local mayor's offices. In some cases, some states issues of very politicized governor's offices, where they're not bringing state charges or they're not bringing local charges. They're letting these people essentially off the hook to go out and commit crimes again the next night. Now, we've seen the federal government attempt to take a couple of different approaches at this. One was putting ICE officers and federal marshals sort of on the front lines. We've also seen recently the decision to deputize local and state police officers as federal marshals in order to federalize charges of violence against police officers. But at some point, something needs to be done, I think, at the political level for some of these district attorneys that won't charge, and so on and so forth. Attorney General Barr had proposed maybe taking a look at civil rights action against local officials that aren't doing your job. Do you think there's a play there? And if so, how do we proceed to sort of get accountability for these local and state officials that are refusing to enforce the law?
Yeah, I'm skeptical of the civil rights angle, and I share the frustration of people who wish that there was a magic wand that we could wave and fix this problem. And I wish that magic wand was in the law. But in point of fact, the main check on these progressive prosecutors is political. The people whose lives are at stake continue to elect these people. So, the main problem in our political culture is the strength of the funding and the political appeal in particularly blue cities. I don't want to get political about this, but it is what it is. These are progressive prosecutors, and it tends to be in very liberal cities that they get elected. And I think the problem there, Kyle, in terms of our political culture, is most of those cities and de facto are one-party jurisdictions. So because there's not a competitive second party, they can pretty much slot who they want in these positions. And particularly what we saw with the district attorneys in particular is that for years, these races were, low five-figure races, largely because they're in one-party jurisdictions. It doesn't require a lot of electioneering in order to get the people who are on the slate elected. And what the big financial backers on the left, I think, saw was that if you overwhelm these races with money, so if you take something that's a $50,000 race and you pour $600,000 into it, you're going to get your person elected. And they've managed to do that again and again and again. Now, you're starting to see public pushback because I think, and this is probably, I assume, why President Trump is running the kind of race that Nixon ran in '68 and that Reagan ran in 1980. People vote on their safety. They may have all kinds of views about public policy and about social policy, but people's votes tend to be about their pocketbooks and their safety. And if they start to feel unsafe in their own cities, Or if they start to feel unsafe through the rest of the country because they see what's going on in the cities and they wonder, are we next? Then that's a powerful political argument. So I think you're seeing some pushback against the progressive prosecutors where you should see it, which is in the political process. The use of the civil rights laws to try to get state officials to do what they should do in order to protect the constitutional rights of the people who are harmed when police don't police and when the law enforcement authorities don't enforce the laws, that's a very tough one, and I think it would be very, very uphill.
Yeah, I mean, it's the sort of thing we actually typically see done more by the left, in that the left seeks to use federal civil rights charges to do what they see as correcting
Right.
the policing of the local or the state authorities.
Yeah, I would just say one other thing about that. The purpose of the civil rights laws is to vindicate the federal rights of individuals who are denied those rights by either some action of government or some action that has a cognizable federal angle to it. The purpose of the civil rights laws is not to make the states subservient to the federal government. And the theory of our government, for better or worse, is that we have dual sovereignty between the federal government and the state governments, and the feds are only supreme in those areas where the Constitution makes them supreme. So to go back to the thing that you asked me before about the federal intervention in the cities, leaving the civil rights laws aside, federal government has a bunch of different functions, right? Number one, the protection of federal installations is a federal responsibility. So no matter what the authorities do in Portland, for example, if a federal courthouse is under siege, the federal government's got to go in and protect that. And if the state won't do its job, the feds have to do it. Then there are areas that Congress has enacted criminal laws in connection with, for example, narcotics trafficking or racketeering we've talked about. We have a dual sovereignty system, not a system where one sovereign is exclusive in any particular area. And what I mean by that is the United States is the sovereign. The federal government is the sovereign, or the agent of the sovereign. We're the people of the sovereign. But in terms of our dual sovereignty system, the federal government is sovereign over every inch of the United States when it comes to the enforcement of federal law. Now, as a matter of prosecutorial discretion, you're much better off using your federal funds in places where you'll get cooperation from the state authorities than in places where you won't, because you'll get more bang for the taxpayer buck for that. But the federal government has the right to come in and enforce federal law any place in the country. And then, Kyle, finally, where you have these situations where you have concurrent jurisdiction, like, for example, again, narcotics trafficking and certain kinds of violent crimes. There is concurrent jurisdiction in the state, in the sense that both the feds and the state have the power to prosecute these crimes. And what you've seen in that regard is Attorney General Barr using existing task force arrangements to beef up the federal end of it, like more FBI agents, more U.S. Marshals, more DEA agents, and give federal funding to the states and the localities so that they can contribute more cops and more state police. And they do a cooperative effort to go after violent crime under circumstances where now, if you're the police, you have the option of taking really bad guys to federal court, where the penalties tend to be more severe and the prosecutions tend to be more serious than what happens in the states. So those are the different options, and it really depends on what the federal interest is with respect to each one.
But I mean, I think, and this gets a little bit back to the question of ideology, which is that if we understand Antifa and some of these other groups to be, as General Barr said, revolutionary groups, which seems to implicitly imply seeking to overthrow the government, seeking to make war on the government, then that creates a very important federal role that doesn't exist. And so even when these guys are trying to burn down local police stations rather than federal courthouses, it still creates a role for the federal government because of this ideological purpose of the riots. The riots are not just about something happening locally in Portland. They are about the nature of the system that we have and their desire to overthrow it. And so I think I, for one, have been very heartened by what the Attorney General has said in his understanding of this. I'm hoping that concept is spreading. I don't know if it is. I mean, I recall the FBI primer on domestic extremism sort of labels Antifa and similar groups under the rubric of anarchist extremism. And if you read what their primer said in 2010, they really pushed it back on the local and state governments, saying most anarchists engage in activities which are local responsibilities. And I think that what we're seeing, I think the American people also want the federal government to understand that this is a federal responsibility to defend our system and our way of life from revolutionary organizations and ideologies. So maybe we'll see more of that in the future if we're lucky. But certainly it seems to be at least some level of understanding. So I think that's very positive. At this point, let's pause from my grilling and see if we have any of our audience questions. Adam, can you? There we are. Adam, do we have any good questions?
Sure. What are your thoughts on the Kyle Rittenhouse case, or so-called vigilantes in general who have intervened in some of the rioting?
The Rittenhouse case is a very, there's a lot of, I spent last week talking about Breonna Taylor and had to observe again and again that it was just an excruciatingly awful case. I think the Rittenhouse case is going to be very similar. Look, I think the thing that I find the most maddening about the Rittenhouse case is it goes to exactly what Kyle and I have been talking about for the last several minutes, which is if the federal government and the state governments are doing their job and maintaining order, you don't need 17-year-old kids to come in, or however old he is, with weapons. I didn't mean to suggest that he's not old enough to be prosecuted. I don't remember off the top of my head how old he is. My point is, you wouldn't have to rely on other people to uphold the law if the local governments understood that it was their responsibility in order to make it understood in the community that the law was going to be upheld. And when order is lost, it's the government's first responsibility to restore order, not to rely on others to do that, because even the police can't do that. I mean, the police can promote law and order as long as you have the rule of law established. But once you lose the establishment of the rule of law, it's got to be reestablished. So my objection to the Rittenhouse case is the fact that the governments didn't do their job. I think he clearly, well, I shouldn't say clearly, because there are interpretations of the gun law that suggest that it might be possible that his possession of that weapon that night was lawful. I tend to think it wasn't, but I'm not as close to the facts as the people who are doing the investigation are. But to charge that case as a murder case under circumstances where he was coming under attack, even allowing for the fact that he shouldn't have been there and that he probably shouldn't have been armed, I just think as a prosecutor, as somebody who was a former prosecutor, I don't like the idea, and we're seeing it again and again and again in a variety of places, of having the politics of the situation determine whether charges are brought rather than have the evidence determine whether charges are brought. And that's why I have so much respect actually for the Attorney General in the State Attorney General in the Breonna Taylor case, Mr. Cameron, because I think even with the mob screaming for one result, he went where the evidence took him. And in those circumstances, even though Ms. Taylor was tragically killed, you couldn't charge the 2 police officers whose shots struck her because they were lawfully there executing a warrant and they were fired on first. Whereas the 3rd cop was never fired on, and he's outside the premises wildly shooting at a sliding door and a window that he couldn't see through, under circumstances where the cops, obviously, they always have to have a line of sight and a reason for what they're shooting at, rather than just spraying bullets around like that guy did. So he was charged, as he should have been, with their version of reckless endangerment. I think they call it wanton endangerment, if I remember the state law term for it. But it seemed to me that in that case, even though the mob is screaming for its version of what justice is, that attorney general followed the law, and I commend him for it.
I'll combine a few questions here that ask about the Insurrection Act as well as proclaiming Antifa a terrorist organization, or BLM, as strategies, I guess.
It's my Marco Rubio moment.
No.
Yeah. So would you address that briefly? Both the Insurrection Act and the possibility of a designation or determining a group as a terrorist organization.
Let me take the second one first, and then I'll get to the Insurrection Act. There's a lot of misunderstanding about the designation process, and I've been addressing this. I feel like I've probably written the same column probably 5 times in the last number of years. There's no need to designate a terrorist organization that operates domestically. The reason that we designate foreign terrorist organizations, which is a process that didn't even exist until about 1995-96, and was largely a result of my case and other instances or indications of attacks on the United States by jihadists beginning in the early 1990s. But notice that when I prosecuted those terrorists, and when my friend Gil Childers prosecuted the World Trade Center bombers slightly before we did, there was no designation process, and it didn't impede us in the slightest. We called them terrorists, we investigated them as terrorists, we prosecuted them as terrorists. I think the indictment in my case, I described count 1 as something along the lines of conspiracy to wage a war of urban terrorism against the United States. I mean, there was no limitation whatsoever by dint of the lack of a designation process. The designation process is specifically for foreign terrorist organizations, and the reason that it is done is because those organizations tend to operate in places outside the jurisdiction of U.S. law. So the idea was Congress was trying to give a leg up to federal investigators under circumstances where the bad guys are operating in places where our agencies don't operate, the writ of our courts doesn't run, and it enables the government to seize funds and designate, as Kyle mentioned before, designate terrorists as, prosecute people for providing material support to terrorists who've been designated, that sort of thing. We need that with respect to international terrorists. With respect to domestic terrorists, we have a ton of laws to prosecute them with at both the federal level and the state level. And you don't want to unlearn the lessons of the 1960s and the 1970s when the problem with terrorism, and I think Kyle mentioned this before as well, is that the use of force against the government is always bound up with political dissent. And you always have the danger of catching some people in the net who aren't terrorists, but just want to express their First Amendment right to oppose the government or government policies or what have you. So we don't want to. The only other reason for designating terrorists is you can use the array of counterintelligence laws against them in order to monitor them, like FISA, which allows us to monitor people that we think are agents of foreign power engaged in clandestine activities against the United States. We don't want to do that with Americans inside the United States, because we have a lot of laws that allow us, if those people are engaged in either violence or plans to commit violence or solicitation of violence, we have plenty of laws we can use against them. So that's why we don't designate. As far as the Insurrection Act is concerned, this goes back, gents, to a point I was trying to make before about the government's responsibility to restore order if order is lost. Under the Constitution, in Article 4 of the Constitution, the government is responsible to protect the states against, for example, foreign invasion. And the government, that's a responsibility the president has, whether he wants to have it or not. I thought a lot of the debate around this subject was kind of wrongheaded, because they kept asking, should President Trump exercise his discretion to send the military in here or to beef up there? When in point of fact, the Constitution doesn't make it his choice. It's the government's responsibility to protect the states. If the hordes came over well, I guess they wouldn't dare do it in Texas, right? But if they came over the border of some state and tried to take it over, you wouldn't. A president who said, "Well, I'll think about whether to get around to that or not, based on whether the mayor cooperates with," I think he'd get impeached the next day, right? So, and rightly so. So that is a federal responsibility. Now, over the years, the Insurrection Act in various iterations goes back to another one of the very first Congresses. And it has given the president expanding authority to intervene in response to unrest in the states. And it's been expanded to the point where it's not necessarily even unrest in the states. It's like natural disasters and other things that aren't anything like war against the United States. Most of the time, it's not controversial, because when a threat is big enough and it imperils security badly enough, the state will want the authorities to come in. I mean, you've heard for the whole coronavirus response that we've had going back to February, March, you've had state after state after state ask the federal government to come in and help. So usually that's the case. There are circumstances where the violence is bad, but it hasn't gotten to the point where you could yet call it an insurrection. It's insurrectionist in the sense that it's tending in that direction, but it may not be there yet. And in those circumstances, I think it's appropriate to say the president has a choice. He certainly got legal authority. There's plenty of historical precedent for it, to send federal forces in to impose order. But nobody should think that that's not fraught with problems. I often point out when I'm asked about this, when I was a kid, the Kent State massacres happened Kent State massacre happened in the early 1970s. That was one of the formative events of the era of 60s and 70s in terms of turning the tide and the historical understanding of that whole period in the Vietnam War and what have you. And it was a tragic event, and had an enduring legacy, and still does, I think, to this day. And the reason I mention it is nobody should think if you send federal forces into a chaotic situation in the states that it necessarily ends well. It can go very badly, and they're very mindful of that. They don't want American military forces shooting on Americans. Nobody wants that to happen. And And when you send military forces into an area, you always run that risk. Now, our guys are very disciplined, and they're the best troops on the planet. But, bad things happen, and nobody wants to be responsible for that. And I think rightly so. So the line that's been drawn, it seems to me, is that where the states have asked for help in those situations where things are not totally out of control beyond the ability of the state to control it, where they've asked for federal help, the president's been willing to give federal help, but otherwise he's pressed the states to say, look, if you want us, we're there, and in the meantime, we're gonna enforce federal law. So we're gonna beef up our task forces. We're gonna do drug cases and violent crime cases and whatever we can do. But again, going back to what I said before, in terms of the bang for your taxpayer buck, you're going to get a lot more out of a situation where there's cooperation between the federal and state authorities than you're going to get if you impose a federal presence on a state or a city that doesn't want it.
I think we'll have to leave it there. Andrew McCarthy, thank you very much for joining us. I think this has been a really important for our audience to understand some of the depths of what's going on here legally, what's required legally, what's possible legally. And I think you also noted, most importantly, when we were talking about restoring order and the role of local officials, the importance of the political process and voting. And as we enter into this period of election, keeping that in mind, that if the American people want to restore law and order and they want security, they need to be willing to vote for local, state, federal officials that are offering it. So thank you again, Andy, very much for your participation. Thank you to our audience. I will also let you know that next week, or actually in just 2 days, my colleague Tommy Waller will be having a webinar on Wednesday, September the 30th. We'll be at our regular time of 1 p.m. and he'll be talking about hackable elections, cyber threats, and foreign interference threats to U.S. elections. His guests will be Kevin Freeman, Hans von Spakovsky, and Russ Ramsland. So look forward to that as well as part of our ongoing election series. Thank you once again for joining us and here at the Center for Security Policy, and please do tune in for that next upcoming webinar. Thank you and have an excellent day.